Have you recently lost a loved one, now find yourself wondering what happens next? Are you confused about the probate process in Florida, how long it takes, or what steps your family may need to go through? In today's video, I'm going to simplify the Florida probate process by walking you through the common steps and timelines and what families can generally expect when settling an estate. First of all, let's just talk about what probate actually is. Probate is a legal process used to settle someone's estate after they pass away. This process can involve identifying assets, paying debts, resolving creditor claims, and eventually distributing assets to heirs or beneficiaries. For many families, probate feels overwhelming, and it's simply because it's never been done before. One important thing to understand is that not every asset has to go through the probate process. Certain assets like jointly owned property, accounts with named beneficiaries, or assets held inside a trust may avoid probate completely. But if assets were owned solely in the deceased person's name, probate is often required in order to legally transfer ownership to their heirs. The first major step in the probate process is determining what type of probate may apply to the estate and filing a case with the court. This usually takes place at the county courts where the person lived. The court will then appoint a personal representative, sometimes called an executor, who is responsible for handling the estate throughout the probate process. The next step involves identifying and gathering the estate assets. This can include bank accounts, real estate, vehicle investments, and other personal property. During this stage, the personal representative may also work with attorneys, financial institutions, and other professionals to properly document the estate assets. Another important step is notifying creditors and addressing any debts or claims against the estate. Florida law gives creditors a certain period of time to come forward and file claims before assets can typically be distributed to heirs. Valid debts and expenses and obligations of the estate usually need to be resolved first. Once the debts and claims have been handled, the remaining assets then can be distributed to beneficiaries or heirs according to the will and according to Florida law. This usually is the stage where families are most anxious to reach, but it's important to understand that the probate is a process that requires several legal steps along the way. Now let's talk about probate timelines, because this is one of the biggest questions that families ask. Every probate case is different. A simple probate administration in Florida may take approximately 6 to 9 months. More complex estates involving disputes, missing documents, creditor issues, or properties that need to be sold can sometimes take a year or longer. One of the biggest misconceptions about probate is that every case becomes a nightmare. That's simply not true. The reality is that understanding the probate process and having proper guidance can make things feel much more manageable and far less stressful for families trying to settle the estate. If you have questions about your Florida probate process, probate timelines, or steps involved in settling the estate, feel free to reach out. We've helped many heirs and families gain clarity and gain confidence while navigating the probate-related questions. Thanks for watching, and I'll see you in the next video.